sheriff is our state law enforcement agency in our county. I found that out. He is the legal one. Who's supposed to be. And he's supposed to be here helping us. Now, we know what happens when, sometimes when that doesn't happen, don't we? There was a 911 call that didn't get answered.
Yes.
So, yeah, don't forget that. He's here to protect the citizens of Houston County. That's his job in the state of Alabama. That's the way it's written. And by the way, I taught government when I was in high school, and I know that it's the court's job to interpret the law, not make it. The legislature makes the law, and then the judges interpret the law. They don't. I've learned that. Ed.
Question. I wanted to ask maybe Attorney Hall, not the Supreme Court candidates, but Troy King has sued BP. The governor said he does not want to sue BP. Can you weave through that situation for me, Attorney Hall? What's going on?
Well, the Attorney General is the elected legal representative for the state. He's supposed to normally work hand in hand with the governor, but here there's been a split on authority. But the Attorney General is empowered, as I understand it, to bring an action on behalf of the state to protect its citizens. That's what he's doing with the lawsuit, because the damages haven't been determined yet. They don't know what they are, but that's okay. If you need to bring the lawsuit now, start preserving the evidence, and then we'll sort out what the number is later. What the governor wants to do is to submit a claim that they have put a number on right now when, in a lot of people's opinions, it's impossible to know what the damages are. And so there's the dispute. Is the governor's mad that we might not get the $148 million claim that's been thrown out right now as a number that they haven't paid anybody else, but the Attorney General has initiated a lawsuit on behalf of the citizens of Alabama for all damages, and a part of that will be to go determine what the damages are. And that lawsuit stops negotiations, according to the governor. It doesn't really happen. It happens every day that you have a lawsuit underway, but you still talk to the other side, and as things develop, as we find evidence, as things are developed, you can talk to the other side and say, well, here's what I think. I found this, 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 and these documents and these doctors. I think it's worth this much money. What do you think? And the other side can come back and say, well, I think it's worth less than you think it is, but what about this number? Well, you can come up with it as the case develops. If the lawsuit's filed, you're empowered to send subpoenas. You have court authority to make BP give you documents, to go to different people and get documents. That allows the state to find out what the damages are. The governor doesn't want to do that. For whatever reason, he thinks it's better just to put up a number, ask for it, and see if they give it to you. So there's the dispute in philosophies. Just because there's a lawsuit underway does not mean the governor can't have a conversation with BP. If they reach a number they agree on, it would have to include stopping the lawsuit, but they can do that if they want to. That's a little bit of politics where the governor's saying we can't negotiate because there's a lawsuit underway. It happens in every single lawsuit. Just because you started the lawsuit doesn't mean we can't stop. We have to stop talking about resolving the conflict. The lawsuit's a way to find out what the facts are so that we can all look at them together and decide what do we do with it. So I don't know if that answers your question, but you can do both. You can negotiate while you're pursuing litigation.
But that's not what the governor is saying.
And that's not what the governor's saying. The governor's saying BP won't talk to us because you sued them.
We don't got to where we don't believe what he says anyway.
Thank you.
Yes.
Yeah, Kenneth.
I guess I'm gonna leave Judge Parsons out of this because I already know his answer. We know each other. John?
Yes, sir.
And you represent Rhonda. How do y'all feel? I won a lawsuit with ex-felon voters' rights. How do y'all feel about the lawsuit for ex-felon voters' rights? Do y'all agree with it?
Ex-felon voters' rights?
Yeah.
When felons could vote in and out of incarceration depending on the crime. If it's a non-violent, non-victimless crime, then they can vote according to the Constitution.
Yes, sir.
Do you agree with that?
I'm a great believer in supporting the Constitution and the right of people to vote. Yes, sir.
Okay, I didn't have to ask Judge because he on the team.
I don't know what Rhonda's position is, but my thought is that a law shouldn't be used as a weapon. It should be used to achieve the purpose it was enacted for. And if the law is don't let some people vote because of their conduct, have forfeited the right to participate in our system. I don't think that's everybody, because felonies can be developed in different statutes and laws down the road later. So it's a little bit broad to just say it's everybody. So I don't know her position, but I think it's a little too broad, and it should be narrowly defined.
Amen. My second question, and this is advice I need to ask y'all this, and I'm asking in front of everybody. When we have a sheriff that's supposed to be the state representative and the chief law enforcement in this area, and at first it was just me and I'm the only preacher he wouldn't let in, but now it's other preachers. And his word to preachers now is choose to be an advocate or a preacher. Y'all being judges, lawyers, and all that, do y'all have that right, or do he have that right? And if he do, could anybody tell me where the Constitution is at now?
In what setting?
What are you talking, I'm sorry.
His words is, preachers that want to go to the jail. For those of y'all don't know, he turned Reverend Jones himself from going to that. For those of y'all that don't know yet, and it will be in those news later on. His thing is, you have to choose to be a preacher or an advocate before you can come in that jail to visit your own members.
And an advocate,
You have to choose to be either or.
If it, as an advocate, what would you be in there doing? Trying to help them with an appeal or their legal claims?
I have no idea.
Sounds like to me that's a Hughes law.
That's what?
A Hughes law.
According to, I think it's a viewpoint discrimination or something like that, isn't it?
I don't know.
I really don't know enough of what the issues are quite right there with all the legal aspects. I certainly know that, sheriffs have a right to control access to their jails. However, prisoners have a right to have access to their attorneys. And for the most part, most sheriffs and virtually all sheriffs recognize the right of the clergy to be able to come in to assist people and to be there. And as a form of an advocate, if that's a form like a lawyer, I mean, it would be consistent with an advocate there. So I'm not quite sure all the details, but those are some of the thoughts that I have right off the cuff. And I'm not, it's a little hard for us. I mean, you're asking some questions that could ultimately be put into a court situation,
Right.
and it could actually come to us. And so we have to be extraordinarily careful how we respond. We're not, the canons put us in a very delicate position of not responding on cases that could potentially be coming to us. To give you an understanding, we can't tell somebody how we will rule on a case before that case gets to us.
Okay, all right, thank you.